Who does?
The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone. Thank you for attending our webinar this afternoon. I'm Pam Mazza, and with me is John Vollmer. For those of you who haven't listened to one of our webinars before or who aren't familiar with the firm, our firm PilieroMazza is in Washington, D.C., and we represent small to mid-sized government contractors as a full-service law firm. So our practice areas include government contracting, corporate counseling, labor and employment law, and all aspects of litigation. If you don't receive our quarterly newsletter and would like to receive it, please send us an email and let us know, and we'll be certain to add you to our list. So we want to get started with an overview so that you will know what's part of the discussion here. And please don't hesitate to send your questions in. We may pick some up going through, but we will try to leave room at the end to answer your questions. And we already have a few, so thank you for those. Today we'll be talking about the definition of a joint venture, the advantages and disadvantages of joint ventures, and then how you start one. And you'll see these 5 steps: finding the right partner, ensuring eligibility, choosing the legal form, determining the management structure, etc., and drafting the joint venture agreement. So the first point is, what is a joint venture? And we've put forth this definition out of the SBA's definitional section of the regulations. So as you can see, a joint venture is an association of individuals or companies that combine to carry out no more a limited purpose, and SBA defines that as no more than 3 specific or limited purpose business ventures for joint profit over a 2-year period. And we'll get into this a little bit more as to what it means later, but for purposes of starting out, know that this is viewed as a separate venture that's organized for a limited purpose for a limited amount of time. So it's not a new corporation that you are establishing to go on in perpetuity. It's limited. So, what? Okay, so John's going to talk about the basics.
Hi, everybody. Good afternoon. So some of the basics here, just setting the stage for what we're going to drill down on as we go along through the presentation. And then, like Pam mentioned, we'll try to pick up a few questions as we go. And a couple of them to this point are about the slides. All the slides will be made available afterwards. I think they're actually on our website right now. And if you participated, you'll get an email with a copy of the slides. And then within a day or so, we will have the audio along with the slides on our website, and that's www.PilieroMazza.com/presentations. So just a little bit on the basics. Some of the main characteristics of a joint venture is that you have co-management. You're going to be sharing profits and losses. And like Pam said, it's for a limited duration. So this is not an ongoing enterprise. It's for a contract or a few contracts. Some of the basics for competing as a joint venture, that you want to form your joint venture before you submit the offer. There's certain things that a joint venture has to do like any other offeror, and those things need to be done before you submit your proposal. And we'll get into some of that later. You're going to have a joint venture agreement, and it may take different forms depending on how you set up the joint venture, and that agreement is going to need to provide for contract performance. How are the parties going to perform the contract? And particularly for set-aside contracts, that's an important detail. The FAR requires that you disclose in your proposal that you're submitting as a joint venture, and we're seeing now with more frequency RFPs that have joint venture specific provisions. So they speak specifically to offerors that are submitting as a joint venture and what's required of them. So you need to be watching out for these provisions when you're pursuing an opportunity through a joint venture. And there's 3 different types of of legal forms that the joint venture could take: a partnership, which is referred to by the SBA as an informal joint venture, an LLC, and a corporation. And we'll drill down onto all those forms as we move along. So let's talk a little bit now about the advantages of doing a joint venture. Why would you do a joint venture? Well, one of the main reasons that you do a joint venture is the government can look to the resources of 2 or more companies in performing the work. So it's not just one prime contractor, it's essentially co-primes is how we look at the JV partner. So you get both companies in the joint venture up at the prime contract level, as opposed to the more hierarchical structure of prime with the sub underneath. So when the sub is an incumbent or has a relationship or a special experience, the government can feel better about having that company up in a co-prime position as opposed to as a subcontractor. The joint venture partners are obviously then able to, when they're combining their resources, to go after and hopefully win larger contracts that they wouldn't otherwise maybe be able to win on their own. Another advantage of the joint venture structure is it helps you to stay small longer. And what we mean by that is that the revenue that the joint venture receives is attributed to the partners in proportion to their interests in the joint venture. By contrast, in a prime-sub relationship, the prime contractor's getting 100% of that revenue, even if it turns around and subcontracts a good chunk of it to another party. So you can slow your revenue growth against your small business size standards by running contracts through a joint venture, as opposed to when you're the prime and you have to sub. And another advantage we've got here is that the minority joint venture partner has a little more control over contract performance. Obviously, if you're in a subcontract position, you don't have any privity with the government. As a minority partner in a joint venture, you're not going to have total control over contract performance, but you're in a more advantageous position than as a subcontractor. The next slide is some of the drawbacks of a joint venture and why it may not work in every instance. Obviously, the party that would have been the prime contractor in sole privity with the government is giving up some control by allowing another firm to come up into a co-prime contractor position with it in the joint venture. The joint venture partners, if you do it as a partnership, in other words, an informal joint venture, are jointly and severally liable for the acts of the joint venture. And we've seen confusion. There can be questions from the government about various aspects of the joint venture, and who's doing the work, who do I talk to, does this entity have any past performance, or did this joint venture just start yesterday? And those are not generally obstacles that are insurmountable, but these are things that we'll oftentimes help clients work on the front end in educating their customers, maybe through a white paper or something like that, about the advantages of a joint venture so you can overcome these issues. But it's important to understand when you're considering it at the outset that you may run into some of these types of issues with your customer and anticipate them ahead of time. Also, terminating the joint venture can be more complicated than a subcontract because you're actually in business with another company. It's not just a contract. It may be more than that. It's a little more complicated to unwind. So before I turn it back over to Pam, I want to get us started on the next section, which is starting a joint venture. And we've broken this down into 5 steps. So if we've got the basics and you understand generally what a joint venture is and the pros and cons to it, and you want to go forward, the first thing you want to do is find the right partner. And it sounds obvious, but it's a critical first step. You want to do your due diligence regarding who you're going to partner up with, because you're going into business with this party. So you don't want to choose lightly. And avoid the desire just to joint venture for the sake of joint venturing. It should be a good fit. A client of mine was recently telling me about how he requires that they have a face-to-face meeting with a prospective joint venture partner, which, maybe you sort of slap your forehead, of course, but you'd be surprised that a lot of times that kind of a step isn't taken. So it's really important that you step through who you're going to be doing business with and what their history is with this particular agency. What are they bringing to the table? What kind of a feel do you get from them? Their name recognition, their cost competitiveness. This isn't an exhaustive list here. I think that the main takeaway is do your due diligence before you proceed to the next step.
Thanks, John. I'm seeing a lot of questions about the 3 and 2 rule, and we're going to get to that in a minute. I want to just follow up on a couple of things that Jonathan said. The first thing is that the joint venture does need to be formed before you submit your offer, and that might mean filing articles of organization if you're an LLC, or if you're a partnership, making some representation that you're a partnership. You need to have your DUNS number and your EIN number in place. Those will be things you're asked for in the proposal. Do you need a written agreement? Well, lawyers always tell you to have a written agreement, and you really should have one. One of the disadvantages that Jonathan pointed out is that sometimes the government's concerned that they won't know who to talk to. How is this going to be operating? How will this be run? Which partner is in control? So that agreement will oftentimes be submitted to the government, and you must assume that the government will ask for it. But that agreement should be drafted in such a way that the government can look at it and see, oh, this will be a smooth operation. It'll be a single belly button. I won't have to run back and forth to these partners to get my questions answered or to mod this contract. So those are some points I wanted to follow up on. And then in addition, where the advantage of being able to take on larger contracts. To me, that's one of the real benefits of the joint venture, and that's why, as we'll talk about the exceptions in a minute, SBA has put some exemptions to affiliation in its regulations to allow for smaller companies to go after larger contracts, and therefore to allow the procuring agencies to put those contracts into the set-aside programs where perhaps without the joint venture vehicle out there, they might be hesitant to set them aside. So we've talked about how you need to vet your joint venture partner. Now, on page 9 of the slides, we're talking about being sure that your joint venture partner meets the eligibility requirements. So this slide pertains to joint ventures pursuing set-aside contracts. And there will be different requirements for joint ventures depending upon the type of set-aside you are pursuing. If you are pursuing a SDVO set-aside, a WOSB set-aside, where you are not that eligible partner, then you need to ask your partner to show you in writing that it is a small business or that it's in a hub zone disadvantaged. And you need to make sure that you're comfortable with that and that that joint venture partner actually understands those eligibility regulations, because otherwise you could be just wasting your bid and proposal dollars. And as probably a lot of you have heard us preach on this presumed loss rule before, under the new regulations, these misrepresentations can almost be construed as de facto false certification. So again, there's a higher need to make sure that these joint ventures meet the eligibility requirements before you decide to submit your proposal. So how does the joint venture qualify as small? Under the SBA's general affiliation rules, any joint venture is considered to be a small business if the combined size of the joint venture partners meets the size standard for the contract. So that's the general rule. You must aggregate the revenues of the two partners for purposes of determining whether you're small. As I said a few minutes ago, SBA has carved out some exceptions to that general rule based upon today's environment, the size of the contracts, and the need to get those bigger contracts into the set-aside environment. So an exception to that general affiliation rule is where each partner to the joint venture is small under the applicable size standard for the solicitation, and either the solicitation is a bundled contract or the procurement is a large procurement. So how do we define a large procurement? For service contracts, so for contracts carrying a NAICS code that's revenue-based, if the government estimate on the procurement exceeds 1/2 of the size standard, then that contract is eligible for this exemption. If it's a people code or a manufacturing code, then if the government estimate on the contract is over $10 million, then that joint venture meets the exception. It's really not the joint venture, though. It's more the size of the contract that dictates whether this exemption will be followed. So if it's one of these, quote, very large contracts, then as long as each joint venture is small, that joint venture itself is considered to be small. The next exception is for joint ventures between an 8A protege and an SBA approved mentor. So an 8A protege can joint venture with its mentor on any set-aside that that 8A company is eligible for, regardless of whether the mentor is large or small. So, for example, an 8A company with a large mentor can joint venture to compete for a small business set-aside or an 8A set-aside. If that 8A company also happens to be SDVOSB, then that mentor-protege team can joint venture for an SDVOSB set-aside. So this is one of the things that clearly gives advantage to the 8A mentor-protege program. In one of the Defense Authorization Acts, actually two of them, Congress asked SBA to establish mentor-protege programs similar to this 8A program for SDVOSBs, HUBZONE companies, and women-owned small businesses. And then the next year in the NDAA of 2013, I think, the SBA was instructed by Congress to establish a mentor-protege program for all small businesses. So SBA is giving an estimate of probably in the next 4 to 6 or 7 months, we may see a proposed rule on this. So if that happens, I think it might be a sea change for some of the other small businesses, and it'll open up a lot of different opportunities. But we'll have to see how SBA comes up with the rule. It may not look the same as the 8A mentor-protege program. So next is the 3 and 2 rule. And this goes back to that definition of joint venture that we talked about. So the 3 and 2 rule is, it needs explanation, because the way it's drafted, it says that joint ventures may not be awarded more than 3 contracts over a 2-year period without a finding of general affiliation between the joint venture partners. But what this really means is that if you're in a joint venture, when you get your first award, not first proposal anymore, that was the old rule, when you get your first contract award, your 2-year period starts to run. And during that 2-year period, you can submit as many proposals as you want until you win your 3rd award, or until expiration of 2 years from the date of the first award. So conceivably, you can receive more than 3 contracts as long as the joint venture submitted these winning proposals before it either won its 3rd contract or before the expiration of that 2-year period, whichever comes first. All right, so this is a change from the way it used to be, and it's a tiny bit confusing. So I actually think it's more beneficial than the old rule. Also, please know that you can form more than one joint venture. The same business partners can form more than one joint venture, but you do want to avoid having all your eggs in the basket with your joint venture partner, because that could lead to a general affiliation finding.
And I'll just step in and answer a couple questions before Pam moves on to the next slide. I saw a few questions folks have asked whether or not the 3 and 2 rule applies to SDVOSB joint ventures. It applies to all small business joint ventures. So the rule that Pam's describing here goes to how does a joint venture qualify as small, which is a threshold component for all the other set-aside programs.
And the same holds true with the information on the previous slides, slide 10. That's for all of the set-asides. If you're looking at the 8A regulations, I'm sorry, the whole SBA regulatory scheme is in 13 CFR. If you're in section 121, know that that whole section pertains to small, and that would be applicable to any of the set-aside programs. And then you look behind it to 24 for 8A, to 25 for SDVOSB, etc. And that gives you the special rules for those programs. But 121 generally applies to all small businesses. So the performance of work requirement. This is the other big benefit of joint ventures, especially going after larger procurements. The joint venture itself must meet the applicable performance of work rule requirement. So you know that if you are doing a service contract, you have to perform 50% of the work with your own labor force. Construction is 15 and 25 for general specialty contracting, I'm sorry. So either the populated joint venture, which we'll get to in a minute, or the joint venture partners of an unpopulated joint venture can satisfy this performance of work requirement. So if you draw a line, above that line is the joint venture itself and the joint venture partners. Any work performed above the line satisfies that limitation on subcontracting, and then you have the remainder of the contract to subcontract out to unrelated parties if you need to. So again, it's a tool to go after contracts that you may not be able to compete for on your own. Now for unpopulated joint ventures, the question is how much of the joint venture's work must be done by each partner. That depends on whether the project is set aside as small, and if so, whether it's set aside under one of the other set-aside programs. So for example, and I think we have more on this later, under the 8A program, the 8A company has to perform at least 40% of the work performed by the joint venture. So let's go specifically now to the joint venture requirements for 8A set-asides. The government can award an 8A sole source and 8A competitive contracts to a joint venture if at least one of the firms is 8A certified and either all of the partners are small under the NAICS code assigned to the procurement, or the 8A firm is certified and small and the other partner is the mentor. SBA must approve the joint venture agreement before contract award, but it doesn't have to approve before you submit your proposal. So know that you may have to go in, talk to your SBA district office, see how they like to proceed. Some will help you out and approve it before you submit, but some say, I will wait and see who wins this contract, and then I will approve the joint venture for the awarded joint venture. So it really depends. It's a little disconcerting sometimes, especially to the non-8A partner, but that's what the SBA rules provide. And here are some things that have to be included in your 8A joint venture agreement. The 8A firm must manage the project, must manage the venture. they must provide the project manager. If it's unpopulated, they have to perform at least 40% of the work being performed by the joint venture. Again, though, the joint venture can perform 50% of the work and subcontract out additional work. And then the agreement has to sort of address the benefits, and that the 8A partner can't just be bringing its 8A status to the table. It has to bring something else. There are some other requirements that are baked into these SBA regulations. And you know, this is not really a plug for the law firm, but you can do a teaming agreement yourself. You can probably do a subcontract with some experience, but you shouldn't draft your first joint venture agreement without help, because it really does have to, A, comply with the regulations, but B, it's really setting up a new relationship that needs to be really thought through.
Thanks, Pam. Before I move into the next slide on SDVOSB joint ventures, I just wanted to hit a couple questions I'm seeing pop up. Both companies do not need to be in the 8A program in order to do a joint venture. You need to have at least one of the companies in the 8A program, and then the other joint venture partner either needs to be small, or it needs to be, if it's a large business, it has to be the SBA approved mentor of the protege. And somebody earlier had asked whether an SBA approved mentor and protege could do a joint venture for an SDVOSB procurement. If the 8A, Pam's point was that if the 8A company is eligible for that particular contract, so it would have to be an 8A and an SDVOSB eligible firm, then yes, they could. The mentor and the protege can joint venture for any federal procurement that the 8A firm happens to be eligible for. And we're getting some more questions about when the slides will be available. They'll be up on our website. In fact, I think they're up already. It's www.PilieroMazza.com/presentations. And you'll also get an email that'll pop in shortly after we're done here with a link to it. And the audio should be up by tomorrow if you'd like to go back over or forward to others in your organization who weren't able to make it today. There's been a few questions about SDVOSB joint ventures, and let me go ahead and start running through the requirements for this type of joint venture. And it is a little bit different for SBA and VA, and I've seen a few questions on that. We'll touch on it. So the SDVOSB joint venture regulations for the SBA and the VA are relatively similar. In fact, the VA's regulations point to the SBA's regulations and say effectively that you've got to follow the SBA regulations when you put your joint venture agreement together. And that's really the main thing that the SBA's SDVOSB JV regs do. They tell you what needs to be in your joint venture agreement. And these are provisions that are very similar to the ones that Pam just described for the 8A program. All of these regs look relatively similar in what they require. So you're going to have the SDVOSB be the managing partner of the joint venture. An employee of the SDVOSB has to be the project manager. And this next point is key. It says, and the individual must be named in the joint venture agreement. A few years ago, I think it had been fairly common practice if you weren't entirely sure who that individual was going to be, because maybe you were going to wait and try to hire an incumbent employee and you didn't know for sure if that person would accept, so you just say, well, it's going to be our employee. There was a case last year where the SBA Office of Hearings and Appeals said that wasn't good enough, that the agreement needed to name a specific individual who is an employee of the SDVOSB, that's what the regulations intend. There seems like there's some flexibility in that ruling and another similar ruling that if you could at least point to the person being named in your proposal, that might allow you to get around it. But just be aware that if you do not name the specific employee of the SDVOSB in your JV agreement, you could have an issue in the event of a protest. The SDVOSB has to receive 51% of the profits. The joint venture agreement needs to get into some specifics about who's doing what. And the idea here, again, like with all these programs, is to ensure that the SDVOSB is getting something of benefit out of the arrangement. And they also want to make sure that there are terms in the agreement that the SDVOSB could enforce against its partner in the event of a dispute. So they're not going to let you get away with vague or boilerplate descriptions of we're both going to work together to get the job done. And there was a case last year on this same issue, in fact a couple cases last year, where people lost contracts because their joint venture agreement did not get into enough detail about who was doing what. And the regulations don't give you a whole lot of guidance, and unlike 8A, there is not a template SDVOSB joint venture agreement that the SBA hands out. So this is, I think, to Pam's good point about not going it alone the first time you're doing a joint venture, because the only time you're going to know whether your joint venture passes muster or not is in the event that you face a post-award protest. And at that point, it's too late to change the joint venture agreement. If the SBA thinks that you didn't hit all the requirements, you're going to be found to be ineligible and you'll lose the contract. So addressing these things up front is critical, because there is no upfront review for SDVOSB joint ventures. 8A has an upfront review. It has to be approved before contract award, but that's not the case for SDVOSB joint ventures through the SBA. And let me underline that last point, through the SBA, because that's a key distinction with the VA. The VA must verify your joint venture prior to contract award. That's one of the key distinctions between the VA requirements and the SBA requirements. And the other key distinction being that the VA requires your joint venture to be a separate legal entity. Now, we could go off on a tangent here about what does that really mean, and is there any type of joint venture that is not a separate legal entity in some definitions? But just suffice to say that that is something the VA regs specifically state that is not stated in the SBA regulations. So it's something unique, but I think that one ends up being a distinction without much difference. But the prior approval one, that is an important difference. So you're going to have a longer lead time than to do an SDVOSB joint venture for a VA project, because you're going to have to get that joint venture verified by CVE. And those of you who have gone through that process know that it's not always a smooth ride. So that's something you have to keep in mind that you don't have to deal with if you're doing an SDVOSB joint venture through any other federal agency that follows the SBA's program. The next slide is on the HUBZONE program. And like I said, all of these different joint venture regs are relatively similar, although uniquely the HUBZONE regulations do not state required provisions for the joint venture agreement like the other regulations do. I think it's a good idea that you follow the same general format, because this is the kind of format the SBA is used to seeing. So in the event of a post-award protest, you're giving them an arrangement that looks like they're expecting it to look. But one of the things that's unique about HUBZONE joint ventures that you don't see for the other programs is that only HUBZONE firms can be in a HUBZONE joint venture. So, we talked about for 8A, you could have another small business or maybe your large business mentor. It's basically the same for SDVOSB. But for HUBZONE, both companies in the joint venture have to be HUBZONE certified. So for that reason, I think primarily that reason, we tend to see less HUBZONE joint ventures than we see for the other programs. So the requirements basically are that you're HUBZONE, that you're small, and similar to SDVOSB, you do not need to get SBA approval for the joint venture before you submit your proposal. And finally, in this section, the JV requirements for woman-owned and economically disadvantaged woman-owned set-asides are newer regulations. We're starting to see more joint ventures, and we're starting to see some protests and rulings on these joint ventures. And I would say that this program is very similar to SDVOSB, both in terms of, and I'm talking about at the SBA SDVOSB, not the VA. So what is required to be in the joint venture agreement is very similar. What has tripped up joint venture partners in cases we've seen is very similar, not naming the project manager, not clearly describing how the WOSB is going to manage and run the project and ultimately benefit. And that's why they want to look at those provisions to see what the WOSB is doing, to understand whether they're clearly benefiting from the arrangement, or are they just bringing their WOSB status to the table and the other company that would not otherwise be eligible is reaping the bulk of the benefits. I put at the end here, ensure that the WOSB will maintain the JV's records, because we had a case that turned specifically on that issue, and the SBA, although the parties had an arrangement to electronically store the records, that wasn't sufficient. They needed to be physically housed with the WOSB. So that's just an interesting recent case that we had on a WOSB joint venture. And as those of you who participate in that program know, you have the online repository, so you're going to upload your joint venture agreement. That's a step that's a little different from the other programs, so just keep that in mind.
Thanks, John. So before I move on to the legal form that you might want to consider for the joint venture, we're seeing some questions on the percentage of work to be performed by the joint venture, and the question is whether it is of the labor or is it of the contract dollars. And it's an interesting and very good question, because last year in the NDAA, Congress changed the definition a bit, and the Congress said that the performance of work rule requirements were based on total contract dollars, and that you couldn't give out more than 50% of those dollars for a service contract, and told the SBA to develop regulations on that, and particularly to take a look at the construction industry and develop regulations regarding that as well. That's the law, but it has not been put into regulations yet. So there's no FAR rule on that, and there's no SBA rule or proposed rule yet. The other component of what Congress did was that they said similarly situated companies could combine to meet that performance of work rule requirement. And it sounds to me like as long as you have a teaming agreement in place, that two SDVOSBs on an SDVOB set-aside could combine to satisfy the performance of work rule requirement. Likewise, there's no proposed rule on this yet. So in discussions with the SBA would tell you to wait for SBA's regulations. But Congress has a law that the President signed that's now the law. So we're kind of in a crack here as to what to do. I would say the best advice is probably to read the solicitation. If the solicitation references the old regulation, then do it that way. If the solicitation references the new law, then do it that way. You can always submit a question asking the contracting officer what is meant. But I think if you follow the terms of the solicitation, you're less likely to find yourself in a troubled spot. And again, we don't know when that proposed rule will be coming out. So let's move to step 3.
And let me just answer real quickly to clarify a few questions I saw. The SDVOSB joint venture approval by CVE, that's only for VA contracts, contracts that are through the VA's Veterans First program. So if it's, for example, one of the questioners asked for the Army, there would be no CVE verification required for that joint venture.
So you've decided, let's say that you have decided that you will form a joint venture. You've vetted your joint venture partner. You have decided that the contract is big enough or that you're small enough to joint venture. Next question, what legal form do you use? And we have listed here 3 options: limited liability company, a partnership, or a corporation. I'm going to quickly dispense with the corporation option because it's really a non-option. If you form a corporation, it's going to say that it's in perpetuity. It really doesn't necessarily meet the definition of a joint venture, and you'll be getting double taxation. Any revenues that come into the joint venture corporation will be taxed, and then any distributions to you as a shareholder company would be taxed as well. So that's not really a viable option. But let's go into these others and the pros and cons of them. Limited liability company first. On the plus side, the members are not liable beyond their initial capital contributions to third parties for the actions of the LLC. The LLC may be treated as a partnership or like an S corporation, which means that you get the pass-through tax benefits. So your LLC would file an informational tax return, and then the revenue would be recognized at the owner level. The cons, we have here that it requires capitalization, but quite frankly, it doesn't require much capitalization to be a legal structure. The amount of capitalization really depends upon the size of the contract and how you decide to capitalize it. There are certain filing fees and annual fees associated with this, plus you do have to prepare documents to adhere to corporate formalities. So in your LLC operating agreement, you'll likely have a requirement for annual meetings. You'll have to have minutes of those meetings and document, etc. So to form the LLC, you file articles of organization with your home state. It can be any state. I mean, if it's a question of corporate governance, most generally the states have about the same laws these days on LLCs. So there's not one state law that's more favorable, generally speaking, over another state. You may have a political reason why you would want to pick a particular state to form your LLC. For example, if it's an 8A set-aside, you may want to form it in the state where the 8A is organized, or in the state where the contract is being performed. That's entirely up to you. Once you have those articles of organization filed, you can do the rest of the things that you need to do to get ready to submit your proposal. You need to obtain your federal tax ID number, register that joint venture in SAM, establish a bank account, and if you need to, register to do business in another state. You're also going to draft an operating agreement. Now, that can be all that you need to do. It depends upon the program and the purpose of the joint venture. If you're an SDVOSB going after a set-aside in that program or an 8A, you may have to also draft a joint venture agreement, which is more bare bones than the operating agreement, but sometimes it's all that the SBA wants to see. So I would say you have to look at that on a case-by-case basis. So switching from LLC to partnership. The pros are, again, same tax status as an LLC. It's considered to be a pass-through entity, so you will pay taxes at your own company level. These are simple to set up. You need a joint venture agreement rather than an operating agreement, but we like to include a lot of the same terms in that agreement. And so it's viewed as more informal. It's maybe informal, maybe not. It depends upon what that joint venture agreement, how it's written. On the con side, the partners are jointly and severally liable for the debts of the partnership. They're also jointly and severally liable for any actions of their partners, including criminal actions. So if you decide to pick this partnership structure versus the LLC, you better make doubly sure that you vet your partner. And I like to say it depends upon the type of work that you're performing and whether or not you're populating that joint venture. You have to look at the total picture before you decide whether to have the partnership structure or the LLC. The process is about the same in terms of drafting. Instead of an operating agreement, you draft a partnership agreement. There are generally no state filing requirements to form the partnership. That's why we say it's less formal, and that isn't as much in terms of filing fees required. But know that the lack of filing might present issues in registering the JV elsewhere. We've had some examples where a bank wanted to see the articles of organization because you have to set up a bank account in the name of the joint venture. Well, your bank may not allow you to do that unless that joint venture has proof that it's actually a separate legal entity. So you may want to start with the bank before you decide how you how you organize this joint venture. Joint ventures still need to register at SAM, and they still need to have a federal tax ID number. Your proposal is going to ask for all of that information. Jonathan?
Okay, so we've made it to step 4, where we're going to determine management, structure, and labor. And just to give you a heads up, we have 2 more steps to go, and we're hoping to stop in about 10 minutes, which will save about 5 minutes at the end to answer any remaining questions. We've got a lot of good questions. It's probably the most questions we've received in the webinars that we're doing, and we're going to follow up with everybody afterwards. So if we don't get your question answered, we'll get to you as soon as we can afterwards, so go ahead and keep firing away. So when you're determining the management structure and the labor, and what we're really talking about here is, are we going to have a management committee? Are we going to be member managed? What are we going to do with the project manager? Some of these decisions are driven by the type of contract you're going after. So the project manager, for example, on a set-aside, like an 8A set-aside project, is going to have certain responsibilities in running the project. That's a requirement of the 8A regulations. A lot of our joint venture LLCs are set up with a management committee, where maybe the party that needs to control the joint venture appoints 2 members to the committee, and the minority JV partner appoints 1 member to the committee, and those 3 individuals then serve as the management board or the management committee in running the company, the entity, while the project manager is running the contract on a day-to-day basis. There are various things you'll have to iron out in your operating or partnership agreement about who's going to be responsible for negotiating subcontracts and contracts, how you're going to communicate with the customer, what are the sources of labor to be employed. And again, some of these decisions are driven by the structure that you choose, populated versus unpopulated. Some are driven by the requirements for the contract and the SBA regulations. But these are the types of issues you're going to have to step through. And populated versus unpopulated, we've alluded to it a little bit, and we've certainly got a number of questions about it. So why don't we jump into populated or unpopulated? What does that mean? Because that's one of the keys in determining the management and structure of the joint venture. A populated joint venture is one that has its own employees. This note, I apologize, this parenthetical here is going to be confusing. I believe that should be on the unpopulated joint venture, but the populated JV is going to have its own employees. So when the people are doing the work, they're going to be wearing the hat of the joint venture entity. They're going to get their paycheck from the joint venture entity. They will be employees of the joint venture entity. This is a less common structure, at least in our experience, and I would say maybe primarily because of it's just easier to set up an unpopulated joint venture, and that'll become more clear when we describe what that is. But Some of the advantages of a populated joint venture structure, so you have one seamless entity performing the work. There's no confusion about how is my project getting performed from the perspective of the customer, because it's one entity, all the people work for that entity, and they're getting the project done. So you have all the employee benefits are from one organization. And some clients say that there's a competitive pricing edge, and that's an analysis you'll need to do for yourselves. But it may be that because the joint venture entity, the LLC, is brand new, there's advantages there from the standpoint of indirect costs that can help that JV overall be a little leaner and meaner when it proposes to the government. It is more costly and administratively burdensome to set up. It has to hire its own employees and everything that entails. The JV entity itself is going to earn the past performance as opposed to the JV partners who aren't involved in the day-to-day on the project. And the partners only receive their proportionate share of the profits, but they're not getting the G&A and other indirect or any of the revenues flowing to them on the project, because it's all staying within the populated JV entity. By contrast, the unpopulated joint venture does not have any of its employees, and here's where we should have had that parenthetical, that it may have a few administrative personnel that work for it, but the idea in the unpopulated JV is that the work is done through the employees of the respective joint venture partners. So they each do their share of the work with their own employees. So they're doing the work with the hat on of the joint venture partner, not the JV itself, so to speak, although they're doing it through the joint venture. So even in trying to explain it right now, you can tell it can be a little confusing to understand and explain how is the work getting done and who's doing the work. And that's one of the disadvantages that you will find with a government customer, and where you may be an opportunity to do some educating, like I had mentioned earlier in the presentation, to let them know how an unpopulated arrangement works. But basically, it's the work is done by the two joint venture partners with their own employees, stay on the payroll of the respective joint venture partners. The joint venture entity itself is basically a shell entity. It can charge a handling fee on top of the work done by the JV partners to cover administrative type expenses of the joint venture. It's generally viewed as a simpler structure, easier to explain to the SBA. It's less costly to set up. But like I said, it can be a little more complicated to explain to the agency how it's operating and who's satisfying the work requirements, etc. But at the bottom here we have similarities, and this is an important bottom line. Whether you choose the unpopulated or populated structure, they both allow you to satisfy the performance of work requirements. You get there a little bit differently depending on which option you choose, but you'll be able to satisfy the requirements using either approach.
So for our last section is drafting the joint venture agreement. And as we've been saying throughout this presentation, what will need to be included in the agreement depends upon A, whether it's a set-aside, and B, the type of set-aside. But these are some of the general terms that you want to include. The purpose of the joint venture. Remember, you are a limited purpose organization. So you may want to have the purpose to submit a proposal on XYZ solicitation, or you may have a little bit broader purpose to, if you know what 3 you're going after, you can put them in, but that could restrict you also because you may be able to submit on more. So you want to define it in limited terms, but give yourself enough room. Designation of the small business as the managing partner. If it's a set-aside, that is important unless you're both small. But for purposes of day-to-day operations and how it will be managed, you should work that out and include it in your agreement anyway. For certain set-asides, you want to say that not less than 51% of the net profits will be distributed to the eligible partner. You do want to define the responsibilities of the partners. If one of you is responsible for contract negotiation, one of you may be responsible for a particular subcontractor on the team, or the joint venture itself could hold those subcontracts. But the more that you know when this agreement is drafted, the more you probably should include in. Both parties must ensure performance of the prime contract. And this is a requirement under the set-aside programs, and the government will want to see this as well, that if something happens to one of the joint venture partners, the other one will step in and take over. That doesn't necessarily excuse the party who withdrew from the joint venture, but it gives the government more knowledge that they're not going to see a lapse of performance even though there are two parties responsible. You do have to designate that accounting administrative records are kept by the managing venture and require that managing venture retain records of contracts completed by the joint venture. Of course, your other partner can have copies of them, but these are generally the requirements under a lot of the status-specific set-aside programs. You want to say that you will comply with the performance of work requirements, but as we discussed earlier, those requirements are changing, so you may just want to make a general statement there without outlining specifically what you intend, unless it's greater than what the requirements are under the regulations. And then you want to have a provision in there for resolving disputes. Sometimes people want to have the owners of the companies meet together to try to resolve before it gets kicked to a mediation. Some people say we just go straight to court, so that's up to you, but you do want to have a disputes provision in there. There are lots of other provisions. These joint venture agreements aren't insignificant, but these are some of the ones that are just common to most. John, do you want to go over some questions? Or?
Yeah, we've got about 5 minutes left, so let's see if we can scroll here and find a few we can answer quickly. Somebody's asked what, if you've got a joint venture, whether or not, if two parties form a joint venture, should one party be the lead venturer, and if so, should they have more than 50% ownership of the JV? If you're doing a joint venture for a set-aside project, like, for example, WOSB or 8A or woman-owned, where at least one of the parties has to have that status, then that party is going to need to be the lead venturer, and they're going to need to have more than a 51% ownership interest of the LLC if that's how you set it up. So you do want a lead venturer. Even if you don't have that requirement, you're going to want to have maybe not necessarily a 51-49 ownership split, but at least a way that it's clear how the joint venture is going to be managed, so that you don't run into issues where neither side is controlling and you can't make decisions.
I agree with that, Jonathan. And one point that I wanted to make is we've seen on the larger, alliant type contracts or the big IDIQ contracts with 50, 100 awardees, where 4 or 5 companies will joint venture to go after that. And so in addition to, so it's likely that not one firm would have 50% of that contract, and you may be having eligibility established based upon multiple companies inside that joint venture. But it is important to have one managing member. I don't think that the agencies would like to see something that looks like it's going to be a little bit of a free-for-all with a lot of different smaller partners involved. But my question is, and this is something to consider, what about those big long-term IDIQ contracts, and do you want to provide for the likelihood that one of those companies will exceed the size standard in the future? Because on some of those contracts, contracting officers are asking for certifications on task orders. So if one of your companies exceeds the size standard and an RFP task order is issued on that IDIQ and that partner is no longer small, your joint venture is not small. So You should have a provision in the joint venture agreement that allows you to buy out that contract, that company, in the event that it's no longer eligible. You can still keep them on as a subcontractor if you'd like, but you don't want to lose eligibility based upon someone's success and growth.
Mm-hmm. I see a few here about SDVOSB joint ventures and how do we ensure that the SDVOSB has control, and if there isn't a concrete requirement about how much of the work that party has to do, what about the concern that they're just going to take the profits and that they're not really going to get anything else out of the project? The SDVOSB firm has to make a significant contribution to the project, but it's not more specified than that. So I agree that there's some gray area there that could be exploited. What the SBA is going to do there is they're going to look to see that you specifically defined the roles and responsibilities with regard to contract performance and negotiating agreements and sources of labor. Those are some of the required provisions we talked about, that you can't just use boilerplate or vague phrases. And so they're looking for boilerplate or vague phrases, and that'll give them the sense that, you know, maybe this SDVOSB really isn't going to make a meaningful contribution, or we just can't tell what their contribution will be. So if you're not specific enough there, that's where you'll run into an issue. So you need to be as specific as you can in those provisions to flesh out what it is that the SDVOSB is going to do.
And I think that's good advice for all of the programs, John.
Mm-hmm. And with that, I think we're out of time, so we'll thank everybody for attending today and for all your great questions. There are many we didn't get to, but we will get to them as quickly as we can offline via email to each of you. And like I said, you'll get a copy of the slides via email, and the audio will be up on our website very soon along with the slides, PilieroMazza.com/presentations. Thank you very much.